99% of the time, you never ask a question that you don't already know the answer to. When we're questioning a witness, we have a script that we're walking through. And that script is generally our journey through our story that we want to tell, the story that we want to paint for the jury. So as he's asking these rudimentary questions from a medical he has to make sure the jury understands the context of what is happening.
I'm hoping that this actually pulls the public in to focus on these issues that we're dealing with in the healthcare system and not make the physicians the bad guys, but really the system itself is the bad guy, because we shouldn't be allowing insurances to dictate how medicine is ran. We should be allowing patients who need specific medications to get it right away and be covered and be affordable. But that's not how it is. Medicine,
law, friendship. This is Dr. Long and Lawyer Nik. You're listening to the Medico-Legal Brief.
One doctor, one lawyer, and a whole lot of gray area. Welcome back to the Medico-Legal Brief, everyone. This is Dr. Long and Lawyer Nik. This week has been all about the Lindsay Clancy trial, and I've been following it so closely, and I have so many questions for Lawyer Nik because I am just so taken aback by what's going on, the line of questioning, and just all the little details that I don't quite understand because I'm a doctor, I'm not a lawyer. So I'm hoping to clarify a lot of these questions today.
And Long, when you first brought up this topic, my first response was, well, what's going on with that trial? And I think it's important to note that some lawyers become really, really obsessed with what's going on in the legal news. So a trial like this has a lot of legal following where lawyers want to know how the defense strategy is going, what the prosecution's doing, and ultimately what the outcome is. But then there's also lawyers like myself that, because I've had so much law in my life, I kind of shy away from keeping up with the tabloid style trials, especially because I know I'll get invested to the point where I'll want to listen to everything and I'll want to critique all the arguments and critique the questioning and critique the objections and really invest myself in it. So I avoid it for the sake of not becoming obsessed. But I do think after looking into it, this is a very, very interesting trial.
Very much so. I was also trying to avoid it. I heard about the case. I knew it was going on, but I really didn't get pulled in until about maybe 4 days ago when Dr. Jennifer Tufts took the stand to do her testimony. And that's when the clip started rotating around the public forum, seeing everyone's commentary, and then watching it through fully from beginning to end. It really hit close to home in terms of how critical and how crucial it is to document appropriately, but also where medicine is heading and what is the public view of what medicine is, and even more what psychiatry is doing for our society. It was really eye-opening. I have a lot of thoughts, but the goal today is not to pick a right or wrong. It's really to break down the trial, and not coming from a legal background, I want to understand how they're asking questions and how they get to the point that they're trying to get to.
Now, Long, before we dive into it, I always think it's important to lay a foundation. So if you don't mind, walk us through just the top level details of what you've learned about this case. Obviously, there's heavy psychiatric theme within this case. There's also the fact that she was a part of the medical community. There's a lot there. Medical employers, medical personnel, doctors, physicians, clinicians are invested because there's so much touching the medical community based on her trial.
Yeah, not only the mother involved at the center of all this was a nurse, but the fact that so many different types of clinicians were involved and they're all taking the stand and giving their testimony. And it has been very eye-opening in both good and bad ways, because you see the inefficiencies of the system. You see how the health system tries to help people, but the resources aren't necessarily readily available. And sometimes when that happens, the public thinks that it is the clinician's fault. So it's the nurse practitioner, the physician's fault for not doing their job, when really the system that we have built as a society just cannot sustain the things that we know are needed. And therefore, this is what's happening. And so the baseline of all this is, obviously, there's certain words that we can't use. Otherwise, we might get dinged by YouTube and our social medias. But Lindsay Clancy was a mother of 3. Her youngest was about 8 months old when she, unfortunately, unalived all 3 of them in the basement of their home. while her husband was out running some errands. This was after a long battle of anxiety, depression, postpartum, which is the period after delivery of her kids. So the postpartum phase is what we title it. She had been to several different clinicians, received several different types of medications. All of that is under scrutiny right now on whether or not it was treated appropriately and whether or not she was diagnosed appropriately. Because this is where you come in. From my understanding, this trial is not determining whether or not she is guilty. The trial is meant to determine whether or not she was in the right mind and understood or knew what she was doing, or whether she was struggling with postpartum psychosis, which is very, very, very rare to ever see, let alone diagnose.
And that's absolutely correct. There is no question as to whether or not she committed these horrific murders, but whether she has a defense of not guilty by reason of insanity. In a situation in which someone is found not guilty by reason of insanity, essentially the jury finds that the defendant committed the criminal act, but the defendant was legally insane at the time and therefore isn't responsible for the crime. Now, that doesn't mean that the defendant just gets to go and walk free. There's a lot of rehab that occurs. Most of the time, you're being committed to some sort of facility for a foreseeable time in the future. And depending on the verdict, there's always a chance that if by some way, shape, or form, the defendant comes back to the right mindset, then they would return to a prison or a jail to face the remainder of their sentence.
I think that's why a lot of people are having some issues with that. Then what is to limit anyone in the future to use this sort of, not excuse, but this line of determination for future murders or future deaths or future wrongdoings. And so it's really interesting to see this play out because it's going to affect not only this case and this family, but it's going to affect future cases. But my question for you is, how do you think the public involvement right now is interfering or helping the trial? Because everyone's watching it. It's on every social media and everyone's got some commentary on it. Does that affect the judge? Does that affect the lawyers? Does that affect the clients?
That's a very good question. When it comes to the judge, we put the judges on the bench. Either they're appointed or they're voted in, and they're given that position because we trust that they can remain impartial and make good judgment calls. Now, ultimately, in a case where a jury is involved, the judge is more so like a referee. The jury is actually going to make the ultimate determination if she is in fact guilty or not guilty by reason of insanity. The important thing to note here is that generally a jury, especially in a trial like this, is sequestered from the public. Essentially, they will put the jury in a hotel. They will take their phones. They will take their access to TV. They'll take their access to social media. They will remove any sort of influence from the outside. That way they can remain impartial. However, in this trial, the defense's motion to sequester the jury was denied by the judge, which means the jury actually had access to the rest of society and remained connected to their family and friends and any sort of influences that would have come from that. Now, as far as lawyers, obviously lawyers can listen to the feedback. They can replay what's going on within the court. They can look at their own notes, and they can end up altering their strategy from a day-to-day position, even from a line of questioning. Not all witness questioning takes place on one day. It generally takes place over the course of several days, and one witness can be on the stand for multiple days in a row. So going back to your home at night, you get the feedback from your spouse, or you watch CNN, or you get some sort of input from another lawyer that's friendly to you. That might influence the direction you take. And then as far as the witnesses and the clients, it can add some pressure. If this is a trial that is garnishing national attention, it might make you a little paranoid. As you mentioned, several clinicians are being put on the stand. As they're on the stand, they're understanding that the media attention that they're getting is coming with the full force of the nation, and every media outlet is watching them. They might be a little bit more careful with what they say or how they present themselves. Their reputation may be on the line. Although they might not be a defendant in this case, there can be social repercussions that occur somewhere down the line in their career, in their personal life.
I never realized that trials could go on as long as they have so far. As we're recording this, they're up to day 13. Is that typical of these really big trials? Is that it can go weeks at a time, or is this an abnormal trial where it's going longer than you would expect?
No, I would expect this type of length for a trial of this nature, lots of witnesses to call, lots of foundation to be laid. Generally speaking, because of the nuance of the not guilty by reason of insanity, there's a lot to what we call in law prove up. You need to prove up credentials. You need to prove up history. You need to really bring in a lot of witnesses. Like you had mentioned, any clinician who had dealt with Miss Clancy has to come in and essentially testify if they could add value. In a world where maybe there wasn't a not guilty by reason of insanity plea, where it was just guilty or innocent, it may have gone a lot faster, or it may have gone a lot longer. The other thing that comes into play is a trial is not essentially just sitting down and doing your opening statements and questioning witnesses. Within it, there's evidence that needs to be put forth. There's motions, there's objections and sidebars, and so much more that goes on in playing the legal game that can extend a trial. But for a trial of this nature, I would expect it to be this long. Sometimes they go on for weeks, sometimes they go on for days. It just depends on how intricate the trial actually is.
And so that means the jury is going to be sequestered for that amount of time. That's a really long time not to be able to speak to your friends, your family, kids. That's rough.
It's a long time to be away from your friends and family, away from social media. In that instance, you actually become very, very close with your other jurors, which then has dynamics down the line when an ultimate decision is reached.
Actually, you lead right into my next question. Obviously, watching movies and TVs, it sounds like the jury has to come to a consensus. Everyone has to agree. So as long as there's one person that doesn't, then they have to keep deliberating. Is that truly how it works in real life?
In most cases, yes. In most jurisdictions, it needs to be unanimous, if not in all jurisdictions. I'm sure there's some sort of caveat that exists in some county somewhere in this country, but that's how you're taught. You need to get a unanimous decision. Now, if just one juror does not agree with the findings of the other jurors, then you get what's called a hung jury. And in that case, there could be a mistrial, there could be a retrial, there could be a situation in which a 2-week trial of this nature could then have to be retried with a brand new set of jurors, going over all the evidence, doing all the witness testimony all over again like it didn't happen in the first place. It's very important that a unanimous decision is reached. And that's where this weird social dynamic comes, because generally speaking, you pick a foreman of the jury and they help lead the discussion. They help speak on behalf of the jury. But at the same time, you have these social pressures that exist to where if there's 12 people in the room and you're the one standout, are you going to be influenced? Are you going to be persuaded? Are you going to be frustrated to the point where you just change your mind just to be done? It's a very interesting take when it comes to juries. We could have a full-blown podcast on jury selection and what jurors do. But for the most part, you just need to recognize the pressures that each juror is under as they sit in the room, ultimately making the decision on another human being's life.
If our viewers want to see it, let's have that conversation. Comment below and let us know. I kind of want to jump right into one of the clips because I have so many questions during the line of questioning of both the prosecution as well as the defense. And I want to see if we can help clarify those.
Yeah. And so to set the stage, when you're in a trial, essentially whoever has the burden of proof gets to present their case first. So in any criminal case, prosecution will essentially get to go first. They will get to choose which witnesses they call. And then you have direct examination and cross-examination, which I'm sure we will get to. But in the line of questioning, you always have to tailor who's asking what and where in the trial they are asking it, whether it is direct questioning or cross-examination, because that changes the dynamics and approaches. But to start, let me go ahead and play this clip.
Time you saw Ms. Clancy on January 6th, 2023.
Yes.
And how did that appointment come about?
So I have questions here. The use of time, and maybe this is due to tradition, wouldn't it be more efficient by just printing out these notes that they're making her read off of? Why can't they just print it all out, hand each juror a copy of all these notes, and then they can just read it on their own time? Why do they have to have these individual people go in and literally just reread the note that they've written?
Well, there's multiple reasons why. In some instances, the notes, for whatever reason, can't be put into evidence. So you need to then have the testimony be the evidence. So in certain situations, you're either trying to elicit testimony that is in and of itself evidence of something happening or evidence of a fact. Other times, you're using the testimony to prove something up, essentially laying a baseline, laying a foundation of what that is, and then talking about why it is reliable, why it is of value, why is it of note, why is it truthful. And I think from this video, I believe it's the prosecution questioning her. What the prosecution is essentially trying to do is they are trying to, one, establish her as a favorable witness to the prosecution, because ultimately they want to prove that Ms. Clancy was not insane at the time of these murders. So they are asking these detailed questions to lay that foundation, to then walk through and have that impact that the jury is listening to. The lawyers in the courtroom only care about judges' rulings and the jury's decision. So they don't care about time. They don't care about how long something's going to take. They have to make sure they accurately and accordingly prove up and question the witness and get the testimony they need for whatever purpose and strategy they want. If they don't do this appropriately, obviously certain rulings can go against them. If they don't do this appropriately, there are conclusions that the jury could come to. And if they don't do it appropriately, there are instances that could result in a mistrial where if an appeal is put forth, the whole trial could end up being retried or a decision is overturned or overruled. It's very important that you are very detailed and diligent, even though it seems very boring and nuanced and monotonous and a waste of time.
Interesting. I feel for Dr. Tufts here, not taking her side in any way, but just listening to her answer questions and being drilled on these questions really takes into my own concern on malpractice and how I document and whether or not AI is going to be a helpful thing or not. Because in her situation as a psychiatrist, they are actually not allowed to use any sort of AI because all of that conversations that they're having with their patients are confidential. It's actually quite hard for me as a primary care physician or family physician to get notes from the psychiatrist because everything is locked up physically, but also electronically. And the only way that we can gain access to these notes is by having the patient sign a HIPAA to allow us to retrieve it and then have to make sure that it's coming from the right places and that we're getting full notes. And sometimes that's hard to do, especially if it's across different clinics or even different hospital systems. And so I understand where the public is critiquing the situation and how everything's so fragmented, because it is fragmented. Our health system, as we know, it's not efficient in any way. The healthcare in the US may be good, but it doesn't mean that it always works in favor of the patient, unfortunately. And it definitely does not work in favor for the physician either.
Now, as a clinician, how are you taught or what is your understanding of when you can break doctor-patient confidentiality and report things to authorities or report things to other individuals? What standard are you held to?
Really, the only time that we have been taught and told legally we're a mandated reporter is if we find that there is some sort of harm to themselves or to others, whether that is child abuse, if we suspect adult abuse or caretaker abuse, or we have concerns that they may be suicidal, then those are things that we have to mandate and actually reach out appropriately to get the right people there to help the patient.
Very similar to the law, and it goes a step further to the intent to commit a crime in the future. So same things usually tell all the clients that there is confidentiality in that room, except if there is any sort of report of child abuse, elderly abuse, harm to oneself, harm to other individuals, the intent to commit a crime, obviously with attorney-client privilege. That privilege is something both of our careers lean heavily on in being able to do our jobs appropriately. But then you get to a trial like this and you realize, okay, the privilege only goes so far because obviously she's being asked all these intimate details about her interactions with the defendant and how she handled each interaction.
There's some public commentary on why did the psychiatrists not reach out to their family members to ask questions? Why did they not reach out to people that were close to Lindsay Clancy? And unfortunately, that is not how the system is built. If you are not on the HIPAA file to release information, we can't even call you and tell you where the patient's at, let alone talk to them about their mental health issues, medical health issues. That is a legal protection that is meant to help the patient. But in this case, the public is using that HIPAA law and saying that is what's causing patients to not be treated appropriately, is that psychiatrists aren't putting in the extra work to get the full picture. But it's not the psychiatrist's fault. It's the system that we are working in that limits our ability to reach out and ask further questions and get more resources because we don't have the funding, we don't have the time. And it just comes with that capitalistic mindset here in the US where time is money. Everything is money, whether that's the patient's time or the clinician's time.
And I think those individuals are just generally uninformed as to what HIPAA is protecting, because overall you want to have those privileged conversations with your physician. You want to be able to tell them the deep, the dark, the dirty, so you are treated appropriately. Now, outside of mandated reporting, obviously the questions are, why didn't the psychiatrist do this and why didn't they do that? Well, where do we draw the line? If you end up getting a sexually transmitted disease, should the doctor be able to call up your father or your mother and say that he or she is worried about your sexual activity? If you end up having an embarrassing sickness, do you want a doctor calling up your friends or your husband or your wife or your children? There are reasons for the confidentiality and reasons for the protection. And frankly, a lot of people don't want to get sued for crossing that line. So they exist for a reason. It's really easy for the onlookers to make these assessments and say, well, this should have happened and that should have happened. But you need to understand the rules that all these professions have to ethically play under to keep their patients and clients safe, as well as protect themselves and protect their license.
Got it. Let's go onward. Let's see what the rest of this clip shows.
And she would feel more anxious after it wore off. And in terms of the trazodone, did she say she had any side effects from the trazodone?
No.
And melatonin, was melatonin?
Melatonin is a chemical that the brain makes that tells us it's time to go to sleep. It's associated with the circadian rhythm. It's
Immediately prescribe a new antidepressant?
Yes.
And was she to continue the Ativan at 1 milligram per night and the melatonin at 5 milligrams per night?
Yes.
And I believe in this note for under condition, you wrote deteriorating?
Yes.
And why is that?
So it sounds like a very strong word. I will give some context that it's not my choice of a word. I have 3 options when I'm filling that out. I can say a patient is improving, unchanged, or deteriorating. So she wasn't improving and she wasn't really unchanged. She appeared a little bit worse than the last time I had seen her. So the best word is to say deteriorating.
Okay. Was there anything about her presentation or affect things that she told you that led you to believe that she was in imminent danger of harming herself or someone else?
So just to comment on the EMR discussion there, EMR is electronic medical record, which is something that nowadays every hospital and every clinic has to have to document and hold your files safely. It basically is the documentation from the physician or the clinician that you're seeing. And there truly are EMRs out there that are very restrictive on how you document. Some of them only have buttons. Some of them don't really allow you to freehand anything. And so what she's saying, I actually do believe, depending on what EMR she is using, she probably is restricted to only choosing those 3 options. A lot of people find that as a problem, and it really is. But when you as a system or an employer can't afford these more expensive EMRs, which has all the different bells and whistles and the functions that you want, then you're stuck with the minimum version, which is something that you can click boxes. I'm hoping that this trial actually will show people that there's a lot of documentation on the back end that patients don't really see. Things that we're constantly having to make sure that we do appropriately, not only for billing and coding purposes, but to make sure that we document our thought processes. But sometimes there's a lot. During a conversation with a psychiatrist, you're spending 30 to 40 minutes having a full-on conversation about what's going on, and they try to put down as much as they can. I'm lucky that nowadays, as a family physician, I can use AI to help summarize that. And it is capturing all of those little details for me, so I don't have to worry about typing the whole time. But then that only makes the assessment and plan portion of it, the very end where I put down my thoughts, how crucial that is. I sympathize with her that she not only is a psychiatrist where she cannot use AI, and 2, it sounds like she's on an EMR that's not the most efficient. And 3, some background on Dr. Jennifer Tufts is she is actually brand new. So when she first started treating Lindsay Clancy, she was only 1 month out of her residency. And there's a lot of people saying, why did she claim to be an expert in this? People have to realize that when you graduate residency from psychiatry residency, you are considered the expert. There is no other clinician out there, once they graduate from whatever pathway they did, that has more training or more knowledge than the psychiatrist that has come out. Sure, she doesn't have independent practice experience yet, but she has definitely seen over 15, 20,000 hours of patient encounters.
And that's similar to the law. Once you pass the bar and you are licensed in your respective state, you are given all of the privileges of every attorney that is currently in that jurisdiction. So as a 26-year-old, I'm arguing elements of a divorce case with another attorney who might be 56 or 66 or 76, who from an experience standpoint has the expert knowledge, but I'm still held to the same standard as a lawyer. Everybody has to start their career somewhere, but the expectation and acknowledgement is that We've already gone through the necessary schooling, the necessary education, the necessary internships and residencies to be qualified in that occupation capacity by the state. Whether it was 1 month or 10 years, people are still going to try to find that scrutiny. Another, based on the questioning, going back to your previous question from the last section, when there is evidence such as notes or video or photos, sometimes the testimony is being used to provide context to what that evidence is. So in this situation, they might actually put forth her notes into evidence. And what they need is the testimony to provide context to what the jury is ultimately going to be looking at. So doctor's notes, I'll be the first to say that y'all's handwriting ain't the best. Sometimes it's chicken scratch. So they have to then review the chicken scratch, review the shorthand, and somehow have some sort of interpretation for that, which is why testimony like this would be important in supporting and adding context to those notes.
Well, that's also a reason why most, if not all, systems are on EMRs now. So everything's typed out. So you don't have to read our chicken scratch anymore, Lawyer Nik.
Wonderful. All right, shall we continue?
If you can't find it, I can bring it up to you.
I think I have it. So I mentioned that it's a great option, but it can be hard to get the insurance coverage for it. Usually you need to have demonstrated that you've tried 4 different antidepressants first, and so that it might be necessary to try another medicine first.
Okay. In that email where she was asking you about ketamine therapy, did she tell you that she was, did she say, I'm still feeling a very low mood, no motivation, just very depressed. This has been going on for months now and I'm getting desperate for something that would work quickly to get me out of this depressed state. Do you remember that being part of the email?
Yes.
Had she indicated thoughts like that to you before, wanting something that would work quickly to help her feel better quickly?
I mean, she may have said that once or twice.
Do you know where, strike that, did you ever recommend ketamine therapy to you, or is this something she broached to you in this email for the first time?
It was something I'd considered because
So what is this lady holding? Because I feel like she's holding a fleshlight to her mouth. Is she just like speaking into it? I'm assuming that that is the court reporter and she's typing out all the notes and recording everything. But I've never seen that contraption before.
That is correct. Obviously, as in medicine, technology and law also moves forward and develops. That is a way for the court reporter to record notes, record what she's hearing. Obviously, there's going to be a recording of the trial and of all the questioning. That is a raw recording. But within this, whichever kind of way she sets up her reporting and her shorthand, she's using that to speak into while also not interfering with the questioning that is going on within the courtroom. If she was just speaking into a microphone, obviously the feedback, her talking would probably distract and interfere, especially sitting that close to the witness. But that would allow her to say the things into her computer without interfering with the actual line of questioning that's going on. Although having that in front of you and it being the first time seeing somebody doing that might be distracting in and of itself.
Very much so. But I also wanted to bring up the thing that Dr. Jennifer Tufts had mentioned, insurance dictating how medicine is ran. We heard that for some patients to get ketamine, insurances will first require that you try a certain amount of medications and failed them before they would cover that ketamine. And that goes for a lot of other types of medication. That goes for heart medication. That goes for diabetic medications. I'm hoping that this actually pulls the public in to focus in on these issues that we're dealing with in the healthcare system and not make the physicians the bad guys, but really the system itself is the bad guy, because we shouldn't be allowing insurances to dictate how medicine is ran. We should be allowing patients who need specific medications to get it right away and be covered and be affordable. But that's not how it is. Physicians every day try to choose the best types of medications out there, but we are almost always limited by the coverage of the patient's insurance.
Of course. I think that's good perspective because insurance obviously plays a major role in the type of treatment that we get. And when it comes to the medications that exist, it's very important that the general population is informed.
Let's jump over to that other clip of the defense cross-examining Dr. Tufts.
Yep. And I want our audience, our listeners, to really pay attention to the style of questioning. When you are taking a witness on direct, which is you have called that witness, you are allowed to ask very open-ended questions. And that's generally the approach. Tell me about what happened that night. Tell me about what you heard. Explain to me why you did A, B, and C. Now, when it comes to cross-examination, which the defense will then cross-examine this witness, the questioning style changes completely to where you can now lead the witness. The questions might be a little bit more abrupt. They might be more yes or no. They might be more direct, where you're asking a very pointed question, looking for a very pointed response, and that's allowed on cross. Pay attention to the nuance that the defense attorney is using here, because that's part of the back and forth. Essentially, a prosecution will take a witness on direct. The defense will have the opportunity to cross-examine, and usually those are very pointed, very leading questions. Then the prosecution can then take the witness on redirect and ask clarifications on those questions, allowing the witness to elaborate. And then the defense can then do a recross where they go back to leading questions. So it's like this game of tennis that goes back and forth, where the way you can hit the ball is different for each player on the court.
Great analogy. I wish you had chosen pickleball, though.
Oh. And then she did take the medication, right?
Yes.
And did you meet with her or talk to her before she actually started to implement that particular regimen?
I had met with her beforehand, but I was not aware of when she made the decision to go ahead and take it.
So you met her on the 15th of September, right?
Yes.
When was the next time you met her?
Can I check?
Sure, absolutely. You can look at anything you want.
September 28th.
And on September 28th, did you discuss with her the fact that she was afraid to take the Zoloft?
Yes.
And did you recommend that she do that?
Well, she said that she was feeling better at that point. And
So it's a real easy question. When you talked with her, did you recommend that she increase or take the Zoloft?
At that visit, I don't think that I did.
Okay. So when did she actually take the Zoloft?
So I just want to pause it here. You can hear the change in questioning from defense. He even stops her to correct her and say, was it yes or no? Now, granted, she's being given a little bit of leeway to add a little bit of context, but one of the most popular objections in questioning is objection non-responsive. So if I say, Long, do you like being a doctor? And you say, well, my Mondays are busy and my Tuesdays are fun, I could object non-responsive. I just need a yes or no. Do you like being a doctor? And you say yes. And now you're held in that world of just that one word answer. That's what leading the witness is. And it does a few things. There's a witness strategy where it flusters the witness, or it makes them look unreliable, or it makes them look not trustworthy, or it makes them look not confident. There's a lot of leeway in just that style of questioning that can end up throwing the witness off and really leading the jury to believe one thing or another about the witness that's on the stand.
She told me in her October 20th visit that she had taken it 1 week prior.
And she told you that when she increased it in accordance with your instructions, she went off the rails, right?
I don't think she used those words, but she had.
What words did she use for you as her doctor?
She felt awful.
Awful. Why did she feel awful? Did she have a stomachache? Did she have a headache? Why did she feel awful?
She did have some stomach aches. She had some diarrhea and had a difficult time eating. She also had increased anxiety. She had some more depressed feelings. She had more difficulty sleeping.
And what was your advice to her as her doctor on the 28th of October, after she told you about the effect that Zoloft had on her?
I told her to stop it. Stop the medication.
Okay. Now, Zoloft being an SSRI, and a patient that is taking the Zoloft, 0.05, we spent Friday afternoon going over the drugs, 0.05 milligrams is the lowest dose, all that. That's the dose that is prescribed. Correct?
It goes up to 200, but that is a starting dose.
For pretty much all of you psychiatrists would agree with that, right? 0.05, right?
50.
50. Okay. And you then told her to stop.
Yes.
What does it mean to titrate something?
To slowly increase the amount.
What do you tell patients when they're on an SSRI as to weaning them off the SSRIs?
Depends what the dose is. If it's a high dose, you need to slowly decrease the dose, so kind of the opposite of titration. But if it's a low dose to begin with, you can stop it.
Are you supposed to tell a person that's on an SSRI to stop immediately or slowly withdraw from it?
At 50 milligrams, it is perfectly fine to stop it immediately.
So you didn't have any concerns at all about telling her to immediately stop taking Zoloft? And what did you do, put her on another drug?
Not immediately.
Okay. So did she relate to you on that October 28th meeting that you had? Was it the 28th or the 26th?
So this is where his line of questioning, I'm trying to understand why, because from me, who obviously works in medicine, I understand Dr. Tufts' choice in decision making. But when he asks it, it seems so clumsy. It seems so elementary. But I'm assuming that is to paint a specific narrative for the jury, who majority of them probably are not working in medicine or in healthcare. Is that what he's doing?
That is correct. When you're a law student, when you're a baby lawyer, and something you hold all throughout your career is majority of the time, 99% of the time, you never ask a question that you don't already know the answer to. When we are questioning a witness, we have a script that we're walking through. And that script is generally our journey through our story that we want to tell, the story that we want to paint for the jury. As he's asking these rudimentary questions from a medical perspective, he has to make sure that the jury understands the context of what is happening. She had mentioned the definition of titrate. Well, majority of just your average people may not know what that word is. The attorney definitely knows what that word is, because he's asking it. That's one instance. The other instance is by getting into a certain rhythm or a certain line of questioning, you might throw off the witness and make them look unreliable. You might make them look confused. And that might be what his strategy here is. If the prosecution is trying to use the psychiatrist to prove that she was not actually insane, then it is the defense's job to show how unreliable and uneducated and how inexperienced she is, and that any reasonable doctor in her position would have found that she is in fact insane. Therefore, she should not be guilty by reason of insanity. Although it seems very monotonous, it seems very clumsy, a lot of it is an act. A lot of it is practiced. A lot of it is already scripted to where we already know what the answers are going to be. And we know that because of depositions that have occurred previously. We know that because of evidence or doctor's notes. Sometimes you've already talked to the witness, and so you know what they're going to say, or based on other witnesses, you know what the response is going to be. So there's a lot of different elements at play here as far as why it looks so clumsy. But I can tell you it is intentional. He is trying to use it as a strategic line of questioning.
She did. I did not list them because.
That means you didn't write it down?
Yes.
So listen, memory, then we'll go by that, right?
Sorry?
We'll go by your memory?
Go by my memory about what? I don't recall exactly which side effects she said, but I recall that they were some of the very common ones, the ones that are temporary.
Hold on. You're telling this jury that you don't recall what the side effects were that she told you, but remember you said they were general? Common? Is that what you said?
Yes, because if they were anything else, I would have documented it.
Well, how
And
she took Zoloft? Did she take Zoloft, SSRI, after having Lassa?
I think she took it for about a week.
You think? Or she did?
She did.
Now, Long, what is an SSRI? I know they've mentioned it several times.
Selective serotonin reuptake inhibitor.
And what does that do, essentially?
It basically works on the serotonin hormones that are released in your body so that it changes those hormonal waves so that you can improve your anxiety and depression. That's our main primary medication used for anxiety and depression. It's usually the first line.
And I know I'm asking you this in the middle of picking and choosing throughout this clip, but that is something that would have been established from a baseline earlier in the questioning, to where he probably would have said, can you please tell me what an SSRI is? What constitutes SSRIs? And then how do you prescribe them, to lay that foundation before he gets into the details of what she actually did with those medications?
And he did, because again, I watched the whole testimony on this and very much belabored all of that. That's coming from someone that knows how to prescribe and diagnose and do those things. It just seemed like it was so much, but you're right. Putting the lens and the hat of someone that doesn't work in healthcare, they need to be walked through those definitions. But the lawyer here, Reddington, brings up a very good point in that if it wasn't documented, how can we trust it? How can we believe it? And that is something that we do learn in medical school and in residency, that if you don't document it, it didn't happen. I do think Dr. Tufts shot herself in the foot in this situation, but I also understand that when you're having to type out these really long notes, I don't know if you've ever seen a psychiatric note before, but they are 3 or 4 times longer than a regular visit with your family physician. They are much more in-depth and dense. For her to have to put down every little detail of side effects, especially if they're common side effects, I understand her decision not to, but I can see now how it's biting her in the butt because the lawyer is picking it piece by piece. But I also imagine that most physicians don't document thinking that one day this is going to be used in a trial.
Something else to note here, which is really important, is the defense's line of questioning almost sounds accusatory. And you would think if you just pulled up this clip randomly without really knowing the context, that this doctor might be the defendant with how aggressive the defense is coming at her. And there's also a world simultaneously that exists where she could be liable. I think he didn't even mention another clip that she is a defendant in another lawsuit, which is civil. But as she's walking through this line of questioning, what goes on in this trial could be evidence in another trial. It could be used for medical malpractice claims. It could be used for any sort of penalty or repercussion by the board that puts her license at risk. So this is a very serious position that doctor is in, because just this line of questioning can open up so much more exposure through the rest of her career, where the end of this trial may not be the end of this situation for this doctor.
It's just so terrible to be dealing with this so early in her career. I think she's doing an okay job, but you can only do so much with what you got. And it's the first time. Guess what? If she ever gets pulled into trial again, I bet she'll be a lot better. But I feel for her. And this trial is just so interesting from a medical legal perspective that I'm looking forward to see how this ends, but also further conversations with you, Lawyer Nik.
Definitely. And regardless, this is publicity for this doctor. There's a saying that any publicity is good publicity, but it is going to be something that she is going to have to deal with during the rest of her career, whether or not she's got some positive reviews or negative reviews from peers and patients. But I just hope that this makes our listeners informed, our medical staff that listen to this podcast take another look at how they document notes and realize that liability is just right around the corner. And so you want to make sure that you're protecting yourself from that liability and from that risk. But overall, this has been an absolutely interesting, amazing discussion, because this really is the intersection of law and medicine. So Dr. Long, I appreciate your questions. I appreciate your openness to ask these questions. And just like you had mentioned, I'm now invested in figuring out what the outcome of this trial ultimately is. There is a lot more discussion to be had once that final verdict is reached. But this is the end of this episode of the Medico-Legal Brief, where medicine meets the law. I'm Lawyer Nik. As always, I'm with Dr. Long. If you haven't already, like, subscribe, comment, follow us on TikTok, follow us on Instagram, and follow us on YouTube and Spotify. We release new episodes every Wednesday at 10 a.m. Central Time. We'll see you on the next episode. Yes, we're doctors. Yes, we're lawyers. No, this podcast is not medical or legal advice. Do not take anything we say as a reason to perform your own heart surgery, represent yourself in court, or diagnose your neighbor's rash. This is for entertainment only. Think of it like hanging out with your smartest, wittiest friends, not a substitute for an actual appointment. If you act on anything we say without talking to your own professional, that's on you. Seriously, don't do that.